Assalamu alaikum wa rahmatullahi wa barakatuh. Ahlan wa sahlan wa marhaban bikum. Welcome to the Moulana Ravat show here on Hilaal TV, channel 347 on DSTV. You know, if there's one thing on which there is total unanimity, on which humanity is totally unanimous, that is death. What happens after death? Different people have different beliefs. As Muslims, we know what is our belief. There's accountability, and then there's either reward or punishment. And it could be punishment for a brief period or punishment in perpetuity, and reward then ultimately in perpetuity. Inshallah, we all are granted Jannah without reckoning and for eternity. Now, death is a reality. We all know that. We believe in that. It's not only Muslims, everyone. No one lives forever. It's a historical fact. With all the advancement of technology and science and everything else, no one has been able to beat death, and they won't be able to. We know that as Muslims. Even with the average lifespan, so to speak, having increased according to stats within a particular time frame and life expectancy and all of these things on its place, you still find people in the prime of their lives dropping dead without no apparent cause. No one can really explain it. We're not talking about those who meet up in accidents and those kind of things. And we know as Muslims that Nabi Sallallahu Alaihi Wasallam has told us that remember death excessively, because how you die is how you will be resurrected, and how you're resurrected is how you will fare on the day of Qiyamah. And that's why we make the dua that, oh Allah, make my last day the best day of my life. But once you're gone from this world, all of your actions cease. But the consequences of your actions do not cease, both good and bad. And whether you've left your state of affairs in the right condition or not, could have an impact on you in your grave, and could have an impact on you in the after, and could make or break your progeny. How many families have been divided as a result of an inheritance dispute? Brothers not speaking to brothers, children not speaking to the surviving parent, spouses having a fallout with their in-laws, and these kind of things. And we have an obligation to a particular point. After that, what happens is in the control of Allah Tabaraka wa Ta'ala and in the choice of the people that we leave behind. But it's part of our obligation to leave our affairs in order, in as far as our inheritance is concerned. And it is for that reason that on an annual basis, Al Barakah Bank also has the World's Week. You see, death is something which we naturally dislike, right? Even Aisha radiallahu anha, the famous hadith of Rasulullah sallallahu alaihi wasallam. You can have a yearning to meet Allah, that's a good thing. But death is something that we have a natural fear and dislike for. But it's a reality. You've got to prepare for it. You can't take it for granted that you'll get to it, because many are those who have passed on without getting to it, and it can create many complications. So we're going to have a discussion around wills with two guests from Al Barakah Bank. The one is Mohamed Raees Hussein, he's an attorney, and the other is Moulana Safwaan Navlakhi, who's a Sharia advisor at Al Barakah Bank. Let me first bring into the discussion on the program today Attorney Mohamed Raees Hussein. Mohamed Raees, assalamu alaikum wa rahmatullahi wa barakatuh, and welcome to the program.
Wa alaikum salam wa rahmatullahi wa barakatuh. Jazakallah Moulana for having us.
Let me start with the very basic question, the importance for an individual to have a will.
So basically a will ensures that upon death of an individual, their assets are distributed according to their wishes. The Holy Prophet Mohammed, peace be upon him, is reported to have said that if a person has something to will, it is not permissible for them to go even 2 nights without having their last will and testament written and kept with them. So for a Muslim, the importance cannot be stressed enough, especially where you are living in a country that does not recognize the laws, inherent laws of Sharia. So basically, those laws are not the law of the land. And if you pass away without a will, then your estate will basically be distributed in terms of South African law in the case of South Africa. So it is of utmost importance that you as a Muslim living in South Africa ensures that he or she has a valid Islamic will in place.
Moulana Safwaan, let me bring you into the discussion. Sharia advisor at Al Barakah Bank. Assalamu alaikum wa rahmatullahi wa barakatuh. Moulana Safwaan, assalamu alaikum wa rahmatullahi wa barakatuh.
Alaikum assalam wa rahmatullahi wa barakatuh, Moulana. Jazakumullah khairan.
So Mohamed Raees has highlighted to us the importance of making sure that you have a will. How much of discretion do you have when you draw up your own will? In terms of Islamic law, how much of freedom is granted in terms of testation?
Bismillahir Rahmanir Rahim. Alhamdulillahi Rabbil Alameen. Wassalatu wassalamu ala Sayyidina Muhammad wa ala alihi wa sahbihi ajma'in. The Islamic law of testation is based on a fundamental belief of Islam, which is Tawheed, the oneness of Allah subhanahu wa ta'ala. And following on from the law of Tawheed, which every Muslim prescribes to, is the belief that everything ultimately belongs to Allah subhanahu wa ta'ala. And we ourselves belong to Allah subhanahu wa ta'ala. So premised on this fundamental belief of Islam, we then come to realize that whatever we own is, yes, it is in our legal, but ultimate ownership of that wealth that we have been bestowed with, that is registered in our names and so forth, lies with Allah subhanahu wa ta'ala. And we have been placed in charge of this wealth. For example, Allah subhanahu wa ta'ala says in the Holy Quran, وَأَنْفِقُوا مِمَّا جَعَلَكُمْ مُسْتَخْلَفِينَ فِيهِ. Spend from that which we have placed you in charge of. We have made you vicegerents in. So this ayah clearly indicates that this is the wealth that we own is simply entrusted to us by Allah subhanahu wa ta'ala. And following from this, we come to realize that if this is not purely and completely and ultimately in our ownership, then we do not have full control of that particular wealth, neither in our lifetime nor after our death. As in our lifetime, we are limited. We cannot spend in haram avenues and so forth. And after our demise, so too there are certain laws of Allah subhanahu wa ta'ala that are prescribed in the Holy Quran in Surah An-Nisa in lengthy ayat spanning approximately 2 pages of the Holy Quran. Allah subhanahu wa ta'ala describes and explains the various laws of inheritance depending on the different scenarios that a person may face or an estate may face after the demise of the testator. So to simply put, Islam, in terms of the laws of inheritance, there is limited freedom of testation. Allah subhanahu wa ta'ala in the Holy Quran, after explaining the laws of inheritance, says, Tilka hududullah, that these are the limits set by Allah subhanahu wa ta'ala. So there is a 2/3 of our estate that we do not have discretion in, whereas the 1/3 of our estate, which is referred to as the wasiyah portion, this is where a person has some discretion, and this is where the limited freedom of testation comes in from an Islamic point of view.
Okay, so we're talking wills, we're talking inheritance with Mohamed Raees Hussain, who's an attorney at Al Baraka Bank, and Safwaan Navlakhi, a Sharia advisor. Safwaan is advising us on the Shari perspectives on the matter, and Mohamed Raees more on the legal perspectives. So Mohamed Raees, coming back to you, you were speaking about why it is important for an individual to have a will. Tell us about some of the requirements that make a will valid, because the last thing you want is to have a will, but legally it's deemed invalid.
Correct. I think something that most people take for granted is not understanding the requirements behind having a valid will. Fair enough, you may write down your wishes on a piece of paper, but that does not qualify as a valid will. So in terms of a valid will, these requirements are regulated in terms of the Wills Act. Firstly, a person has to be over the age of 16 in order to make a valid will. This will has to be in writing, and it must be signed by the testator, who is the person making the will, together with 2 competent witnesses. In respect of the witnesses, they have to be independent and of an age of 14 years or older. If there are any amendments made to the will document itself, these have to be signed by the testator as well as the witnesses in order for it to remain valid. If an amendment or an alteration is made to the will and this is not signed, then obviously there is the likelihood that that amendment may not be considered valid. And there are circumstances or situations rather where, the entire will may be disregarded by the master of the High Court. So it is very important when you make a will to obviously ensure that these requirements are complied with.
What about, you said the witnesses need to be independent. Can an executor be a witness? Can an heir be a witness?
So in terms of your heirs, obviously this is something that is, advised against, because obviously if you're signing it as an heir, as a witness, then there is this notion that you may have swayed the testator in a way. So in terms of the law, an heir or valid heir is not entitled to sign as a witness. So it's obviously an independent person. You can, if you're signing at an attorney's office, then obviously the attorney will make provision for witnesses, but it has to be independent witnesses, as well as the executor, because you're being nominated as an executor in the will. You don't want to have the perception that you have swayed the testator in a way that you have now been nominated as the executor. So it is advised that the heirs as well as the executor should not sign as witnesses to the will.
Safwaan, in terms of the Islamic religious obligation of having an Islamic will, can you elaborate on that for us?
Certainly. So as I was explaining earlier, Allah subhanahu wa ta'ala refers to all these laws of inheritance that He mentioned in the Holy Quran. Allah says, وَتِلْكَ حُدُودُ اللَّهِ. These are the limits that have been set and prescribed by Allah subhanahu wa ta'ala. Whoever adheres and stays within these limits, then Allah subhanahu wa ta'ala promises him great amount of rewards and Jannah. Whereas the person who goes against and transgresses these limits, then he will be subject to eternal punishment in the fire. May Allah subhanahu wa ta'ala protect us. So this is the limits that Allah subhanahu wa ta'ala has set, and it is clearly understood from these verses of the Holy Quran that the laws of inheritance are compulsory to adhere to. There is no option in the matter. So it is something that we have no choice in, and it is, as we could say, fard or wajib. Now, there is a principle in Islamic law that says that if anything, any wajib or any fard, anything that is compulsory cannot be achieved means, then adopting those means becomes wajib and compulsory in itself. So in our context, we know that should I not prepare and sign a valid will, my estate will not be dissolved in accordance with Islamic law, and certain people will lose out. Therefore, it is necessary for me to prepare an Islamic will to ensure that all my Quranic heirs, my Islamic heirs, receive what they are rightfully entitled to in terms of the laws prescribed by Allah subhanahu wa ta'ala. So based on this, we can say that to have a will is compulsory, it is wajib, and any person who does not prepare a will, despite understanding the repercussions of not having a valid will, he will be answerable to Allah subhanahu wa ta'ala. He will be deemed sinful because he has not carried out an act necessary to allow the implementation of the Islamic laws of inheritance with regards to his estate.
So Moulana, Mohamed Raees explained to us that legally speaking, a will is it must be written out, it must be signed by the testator, there must be independent witnesses, etc. Islamically, does it have to be in writing, or would a verbal kind of indication suffice? Many times when you tell people, look, you've got to sort out your will, they say, I spoke to my children, they know what to do. Or, the one spouse will talk about the other spouse. My husband knows what to do, or my wife knows what to do. They know what are my desires, they know what are my wishes.
So, although speaking in principle in terms of Islamic law, it is permissible to express your will or your bequest verbally. However, in our context, living in a non-Islamic land, it is highly unadvisable. It has often led to people taking advantage of the situation of usurping the rights of other heirs, especially where we have registered assets. It is not possible for these assets to be devolve upon the heirs except through a verbal will in terms of South African law is invalid, and therefore, in our context, we cannot say that it will be acceptable because it will not be implementable. There will be no force to that particular verbal bequest or verbal will.
Okay, it's time for our first break. We are talking to Safwaan Navlakhi and Brother Mohamed Raees Hussein about wills. After the break, we continue. Welcome back. So we have Mohamed Raees Hussein, who's an attorney at Al Baraka Bank, and Moulana Safwaan Navlakhi, who's the Sharia advisor at Al Baraka Bank. We're talking about wills. And in the first segment, we spoke about the importance of having a will, legally as well as Islamically. What are the fundamentals, the requirements of a will? And I mentioned in my introduction, it's something we all take for granted. When you talk about it, people nod their heads. Yeah, it's important. I need to get it done. But we procrastinate, and sometimes with serious and very grave consequences. Mohamed Raees, if I can come back to you, right? What would you say are the implications in terms of South African law of not having a valid will?
Thanks, Moulana. So for a Muslim to not have a valid will and to pass away without a valid will in South Africa would mean that their estate will be administered in terms of the Interstate Succession Act, which is contrary to the Sharia. So what would happen in terms of the Interstate Succession Act is that it would determine who your heirs are upon your death, as well as the percentages that each heir would receive, which again is contrary to the Sharia. In terms of the Sharia, your heirs can only be determined once you pass away. So in the event of a Muslim passing away without a valid will in South Africa, there's obviously consequences for this, not only in this world, as I've just mentioned, but also in the hereafter, as you would have neglected your duty to have distributed your estate to your rightful heirs. So accordingly, having an Islamic will in South Africa, in a South African context, is of utmost importance and extremely, extremely important for every Muslim to ensure that they have a valid will in place.
If you die without a will, Mohamed Raees, interstate heirs you call it, and if the heirs, say, no, we want to do it the right way, the Islamic way, will the master of the court allow that? Or do they say, no, sorry, the person passed away without a will, we go according to what the law of the land says?
In order for this to be done and for the redistribution agreement to be entered into, what would be needed is consensus from all heirs. Mm-hmm. So if all heirs agree then that they want to now distribute their late parents or the deceased estate according to the laws of Sharia, then they can then do that. However, if you have one or two heirs that say no, they could be receiving a higher percentage in terms of South African law, and on that basis refuse to then enter into that redistribution agreement. This is then where it becomes a bit complicated in that the law will then follow the South African way of distributing that estate, which is again against the Sharia law. So it is a bit tricky. There are options available. However, this then comes down to consensus being reached between the heirs.
Okay, Safwaan, you spoke earlier on, right, that the shares are already predetermined. It's there in the deen. What if the testator, the person drawing up the will, is aggrieved with one or some of the heirs? For example, a parent may feel, my children neglected me. They put me in an old age home. My son kicked me out of the house because I had issues with his wife. Or in some instances where where a person doesn't have male offspring and your siblings inherit, you hear the sentiment, they say, no, my siblings did nothing for me. My brother is living in the UK for the last 40 years. He hardly ever makes a phone call. Why must he inherit from me? I don't want him to inherit. What kind of discretion does the Sharia, if any, give to the testator in this regard?
Jazakumullah khairan. That's a very pertinent question and an issue that we hear about all the time. Indeed, we are in a sad state of affairs when it comes to fulfilling each other's responsibilities, be it between siblings, be it between parents and children, and so forth. So this is an important point for us to improve on. Nonetheless, should a person be faced with a situation where they feel that one or more of the heirs is not deserving of their share of that estate, then we come back to the whole premise upon which the laws of inheritance are based, and that is the Tawheed, the oneness of Allah subhanahu wa ta'ala, and the fact that Allah subhanahu wa ta'ala is the ultimate owner of everything. And once we truly internalize and entrench this belief within our hearts, then it will become easy for us to know that this is beyond our discretion. It is not something where we have a choice in the matter. The wealth that we have in our accounts does not really belong to us, but it is belonging to Allah subhanahu wa ta'ala, and we do not have that amount of discretion that we would like to have, and to try and get back at people who have not fulfilled our rights during our worldly lives. And importantly, it's the reality is that if a person has to go down this route and draw up a non-Islamic will to prejudice one or more of the heirs, then they are actually hurting nobody but themselves. Because once they close their eyes, they have zero access and zero benefit from that particular wealth. Somebody else is going to get it instead of your brother or your sister or whoever it is, or that son who did not take care of you. But you are not going to get anything of that. So you are not getting any benefit on one hand, and on the other hand, you are really inflicting severe harm upon yourself. And how is this? This is explained in the hadith of Rasulullah sallallahu alaihi wasallam, narrated by Imam Abu Dawood and Imam Tirmidhi rahimahumullah. It is a hadith recorded on the authority of Abu Hurairah radiallahu anhu, where he says that Rasulullah sallallahu alaihi wasallam said that a man and a woman can worship Allah subhanahu wa ta'ala for 60 years. So they basically lived a life of piety. They obeyed Allah subhanahu wa ta'ala, they worshipped Allah subhanahu wa ta'ala. And then death approaches them after 60 years of worshipping Allah. They now reach the end of their lives. What do they do now? They act unjustly in their bequest, that is, in their will. They do something to usurp the rights of one of the entitled Islamic heirs. And as a result of this one act, they nullify their lifetime of ibadah, of worship, of good deeds. And if we have to just take a moment to ponder, why is there such a severe warning, such a severe punishment? That entire lifetime of ibadah is nullified because of this one act, which outwardly seems to be, not that significant. We will understand that it is significant because doing this goes against the principle of Tawheed, the oneness of Allah, and the fact that everything belongs to Allah subhanahu wa ta'ala. So when a person does this, he actually, in his heart, he believes that it's mine and I can do with it as I please. Whereas the belief of Iman and Islam is that this belongs to Allah subhanahu wa ta'ala, and I can only do that which I am permitted to do by Allah subhanahu wa ta'ala. So, by doing this, you are hurting nobody but yourself, and whoever has ill-treated you or not fulfilled your rights, that is a separate account that will be dealt with in the akhirah. As for your estate, this is something which is beyond our discretion, and we subhanahu wa ta'ala and let the laws of Islamic inheritance prevail.
So what if a testator says, Moulana, okay, I don't want to cut anybody out. I'm not angry with any of my heirs, but my one son has done much more for me than the other. I've stayed, for so many years with the one son. He's paid all my medical bills. He hasn't charged me for food or, for any of the usage of, the items in his house, etc., etc. Can I then give that son a little extra from my 1/3? Can I, in other words, make a wasiyah or a bequest for one heir or a few heirs, because I feel that they've done a little extra or they deserve a little more?
Rasulullah sallallahu alayhi wasallam has mentioned in a hadith with regards to this matter, la wasiyata liwarithin, that there is no bequest, there is no wasiyah for an heir. So if a person is an heir to an estate, then they cannot be given wasiyah. And in the event they are given wasiyah, that wasiyah cannot be enforced, it cannot be implemented except with the permission of the other heirs. So what it would be then, it would be, so heirs to this particular heir who has been nominated. But in principle, it is not correct. It is not allowed for an heir, for a testator rather, to as a beneficiary in terms of a wasiyah, in terms of a bequest.
So, Mohamed Raees, talk to us about the executor, right? Sometimes people may be inclined, okay, my father or my son or my spouse or my eldest child, I'm going to appoint them as an executor. What are the qualities that you need to look for in an executor? What is an executor actually expected to do?
Yeah, so in terms of testation, a testator, the person making the will, does have that freedom to nominate any person that he or she wishes to be the executor. However, in doing so, it is important.
Mohamed Raees, I'm just trying to see your video. We've lost your image there. Okay, we're just trying to get both our guests back. You know, technology has its challenges. We're talking about wills, and we're talking about the different issues pertaining to how you go about drafting your will. Let's take an ad break. When we come back, we'll continue the discussion both with Mohamed Raees Hussein and Moulana Safwaan Navlakhi. Welcome back. So we continue the discussion. Mohamed Raees Hussein is an attorney with Al Baraka Bank, and Moulana Safwaan Navlakhi is a Sharia advisor. We're talking about wills. All right, so Mohamed Raees, talk to us about an executor. What kind of qualities, what kind of skills does an executor require? Normally people would think, okay, my spouse will be my executor, my eldest child, my eldest son, my father, my brother, that kind of thing. What should we keep in mind when choosing an executor?
Has freedom of testation in that he or she can nominate any person of their choosing to be the executor of their estate. However, in doing so, it must be borne in mind that the person being nominated to act as the executor of your estate must have specialized knowledge and expertise on how to administer your estate, as this process is a lengthy and arduous process which requires strict compliance with the laws and regulations. So in nominating an executor, it's always important to nominate an alternate executor. This will ensure that if your first choice of executor is unable to perform his or her duties for whatever reason, or predeceases you, that you do have an alternate executor nominated in the will itself. So nominating an institution such as Al Baraka Bank as the executor would then provide you with the added comfort of knowing that there would be permanence of the executor. It will not be the same if you had nominated a natural person who, as mentioned a short while ago, may predecease you or may be unable to carry out those duties and responsibilities. So in nominating an institution such as Al Baraka Bank, you get that peace of mind that the executor will never predecease me. And together with that, you have the in-house legal team at Al Baraka Bank, together with its Sharia advisors, who will then guide the process from start to finish, and obviously ensure that your estate is then administered in the quickest manner, and most importantly, in terms of the Sharia.
You spoke there about an alternate executor. So as an example, say someone says, okay, I put my eldest child as an executor. If you put a second name, does it automatically mean that there's two executors? Or could you state it such, failing which, if the one predeceases me or is incapacitated or is not willing, then the second? I would assume that having one executor sometimes in terms of formalities makes it a little bit easier. Otherwise, some people say, I'll put all 5 of my kids as executors. Each one's got to initial every page and sign every document.
Correct. Nominating more than one simultaneously. So if you nominate, for example, as you mentioned, 5 executors, 5 of you required to sign all the initial reporting documentation, there is the option later on for them to nominate either one of them to act in terms of a power of attorney, where then only one person may act and sign documents. But together with that, there is the option, as is seen in the Al Baraka Bank Sharia world, where you can nominate one executor, and then in the event of that executor then not being able to undertake the responsibilities or refusing to do so or predeceasing you as well, then the alternate executor clause comes in, where that person now acts as the executor of your estate.
What about payment? I mean, is there a cap legally in terms of how much the executor can take? And is it only lawyers, or in this case, like Al Baraka Bank, that can charge to administer a will? Or can an heir also charge? If you put your son or you put your father as an executor to your estate, can they say, well, my time and a lot of other things, I want to take a percentage?
So the administration process, like I mentioned earlier, is an arduous one. It requires intensive work in order to administer the estate. So in terms of the law, there is a standard fee, which is 3.5% of the total asset value of that estate. That, in terms of the law, is due to the executor, be that an institution such as Al Baraka Bank or an heir for that matter. Bearing in mind that where it is an institution that does charge VAT, the institution is also can also then charge VAT on that fee as well. So it would be the executor's fee at 3.5% plus VAT that an institution would charge for the administration of an estate.
Safwaan, on that very point, if I can bring you in from an Islamic perspective, if the executor is already an heir, earlier on you explained to us that an heir cannot get a bequest, right? There's no wasiyah for an heir. Can the heir charge if the heir is the executor? If there's multiple children and a surviving spouse, and the one child is made the executor, they say, well, look, I'm entitled to an extra 3.5% for my duties as an executor.
Yes, so when an heir is appointed as an executor, they do not receive a fee for being appointed as an executor, but they receive a fee for doing the necessary administrative tasks that is required to execute that will and to ensure that the assets are distributed to the rightful heirs. So the executor's fee would not be a share of the estate, as in he is now receiving more as an heir. Rather, it is payment for services that he is rendering to the heirs as a collective. So from that point of view, we understand that he is not benefiting more than the other heirs. He is simply getting remunerated for the additional work that he is putting in to administer that estate.
Now, if a will is non-compliant, how can it be rectified from an Islamic perspective?
The easiest method of rectifying that will would be to re-sign a new will, or to sign a new will that is Islamic and Sharia compliant. That signing of a new and updated will would nullify wills that have been signed in the past, and this would now be the will that is taken into account when dissolving a deceased estate.
Community of property, Safwaan, is a common one. Many people, especially the elderly, back in the day when there wasn't this kind of awareness around the Islamic law of succession and that kind of thing, got married in community of property, not really knowing or understanding what it is. So take a house as an example. The husband will say, no, it's my house. I bought it, I paid for it. But the documents will reflect a 50-50% partnership in that house on the basis that they were married at that time when they registered the marriage in community of property. How do you navigate around such a situation from an Islamic perspective when it comes to inheritance?
So this is indeed a common issue that we find in Islamic marriage, in Islamic communities, in the Muslim community. We find that many of the older people, especially who were not educated at that point in time, entered into community of property marriages, and they did not understand the repercussions of it. However, there are others who did understand the repercussions and felt it fair to divide their estate or share their estate with their wives, if their wives, especially where the wife is taking care of the kids and so forth. So they would truly believe that this house or my assets are jointly owned between myself and my wife. So obviously, where there is such an understanding between the husband and wife, that everything that we own, the house, the car, all the major assets are jointly owned between us as partners, then obviously that would leave no room for real debate. However, the problem comes about where that is not the real understanding and the situation on the ground between the two parties. We just have a formal registration in terms of the deeds registry. We have the house registered on their names as 50-50 owners. In this instance, what needs to happen is one of two things. On one side, the children could condone and allow the surviving father or the surviving mother to take that additional 50%, which this surviving spouse is entitled to in terms of community of property. The children would say, no problem, you can have it, and that would resolve the issue. Failing that, what would be necessary to ensure compliance with the Islamic requirements is that the remaining, this particular spouse, the surviving spouse, would have to redistribute that portion of the estate to the other heirs in accordance with the Islamic shares that have been stipulated. So it all depends on who the other surviving heirs are. But it would be necessary for them to do that, because whatever they now have taken from the estate as a surviving spouse in terms of a community of property marriage, it would not be the entitlement in terms of Islamic law, in terms of Sharia, and they would therefore need to return that wealth to the rightful owner.
So, Raees, what are some of the practical considerations which people must take into account when making a will and when preparing for death?
So death is a certainty, and as mentioned in the Quran, every soul will taste death. As such, it is not only important to have a valid Islamic will in place to ensure that your assets are distributed in accordance with the Sharia, but it is equally important that you make the necessary arrangements which will then alleviate the uncertainty and stress of your family upon your demise. Some of these considerations would include providing a copy of your will to your executor and family, and also advising them on the whereabouts of the original will so that it may be easily retrieved when you pass away. Preparing and maintaining a schedule of your assets and liability will undoubtedly expedite the process and assist your executor in the administration process. So in this regard, one should keep a record of bank accounts, properties owned, insurance policies, pension and provident fund details, and similar items. So it is also important that one prepares a file with these important documentation together with a copy of your ID and marriage certificate if married, as well as ID copies of your spouse as well as heirs. So these are also readily available in the event of your death and then the executor calling upon these important documents. One should also ensure that the necessary arrangements are made in respect of any minor children that you may have, and also to leave sufficient funds behind for your dependents' living expenses as soon as you pass away and an institution has been advised of your death. These accounts will be frozen, and any transactions that obviously occur after the date of your death will then be considered a fraud on that account as well. So it's important to then leave behind sufficient funds for them to continue living, as well as to administer the estate, which does take quite a bit of funds depending on the value of the estate itself.
Safwaan, these days for tax reasons and other business-related reasons, people put their assets into trusts. What should they keep in mind when it comes to inheritance and as far as trusts are concerned?
Yes, many people use trusts for various reasons. The fundamental principle to understand so when it comes to trust is that a trust is not a valid owner of property in terms of Islamic law. So it is not a recognized separate entity from the donor or the person who has placed assets in a trust. Yes, what people sometimes do is they place assets in a trust, and those assets are actually placed in there for tax efficiency and whatever other reasons. However, they truly are the owners of those particular assets within that trust. And in this particular, in such a scenario, that the assets in that trust would have to be divided to the rightful Islamic heirs using the legal means, and things get complicated. So it is necessary to consult with legal professionals whilst also taking Sharia advice on these matters. So that is one scenario where a person places assets in a trust and he is the sole owner of those assets, truly speaking. On the other hand, you may have a person who places assets in a trust for tax efficiency and to reduce the estate duties that would be payable on the estate. And through this trust, what they do is they divide their wealth to their family members or to their heirs whilst they are alive. And in so doing, his heirs, or the so-called heirs, or the family members, the beneficiaries, become the owners, the Sharia owners of these assets during the life of their father or whoever the testator may be. So in such an instance where through the trust, actual ownership of the assets has been passed on to the beneficiaries of the trust, necessary to do anything, because that would constitute a donation, a hiba, and those assets would be deemed to be, from an Islamic point of view, beneficiaries. However, if there is no such understanding, then obviously those assets would form part of the Islamic estate, even though they would not form part of the legal estate in terms of South African law. And it is the duty of the testator to ensure that the necessary measures are put in place, people are informed of what is required to be done prior to their death. They need to ensure that all this is in place to ensure that once they pass away, then it will be easy and possible for the rightful Islamic heirs to receive their share of these assets that are sitting within this trust.
Just to conclude then, Mohamed Raees, what is Al Barakah Bank's involvement or contribution towards the National Wills Week initiative?
So at Al Barakah Bank, we understand the importance of having an Islamic will, and we have thus partnered with our panel attorneys and will be embarking on a wills campaign in Durban, Gauteng, as well as Cape Town. As part of this campaign, you will not only receive a free Sharia compliant will, but you will have the opportunity to consult with our attorneys, as well as in-house legal team and Sharia advisors. The campaign will be held in Durban on the 12th and 13th of September, in Indonesia and Lodi on the 14th of September, Rosebank on 15th of September, and in the Cape Town region on the 14th and 15th of September. So to receive your free will and consultation, you may attend at any of the branches on the dates mentioned.
Mohamed Raees Hussain, attorney at Al Barakah Bank, and safwaan Navlakhi, Sharia advisor at Al Barakah Bank. Jazakumullah for joining us for this all-important discussion around wills.
Jazakallah, Moulana.
Assalamu alaikum wa rahmatullahi wa barakatuh.
Wa
Well, there you have it, viewers. Don't delay. Sometimes, we feel, this is just heavy stuff. I'll get to it. It's not as difficult as you would think, but it's not as trivial as we sometimes make it out to be. Get it done and get it done right. You don't want to leave your family fighting. You don't want to leave them in ambiguity after your demise, and you don't want to be answerable in your grave for not having left all of your work in the right order in as far as your estate, your will, and your financial affairs are concerned. May Allah bless us all. Until next week, Assalamu alaikum wa rahmatullahi wa barakatuh.